Welcome to Lex Nova Junior. Today, we're diving into a crucial topic, the administrative powers of a legal guardian, known in many legal systems as a tutor. Exploremos lo que un tutor puede y no puede hacer con los bienes del niño o adolescente que está protegiendo, a menudo llamado pupilo o alumno. First, let's get the basics down. A guardian's role is similar to that of a parent exercising parental authority. They act as the legal representative for the ward. This means that when a guardian enters into a contract or makes a business decision, it directly affects the ward's assets. It's vital that the guardian always specifies they are acting on behalf of the ward. If they don't, they could be held personally responsible, especially if the deal turns out to be unfavorable for the child. So, how far does this power of administration extend? Generally, the guardian manages all the property and assets belonging to the ward. However, there are some important exceptions, much like the limitations placed on parents. Por ejemplo, cualquier propiedad que el tutelado adquiera a través de su propio trabajo o profesión está fuera de su alcance. Si el adolescente tiene más de 16 años, podrá administrar estas ganancias y cualquier ingreso proveniente de ellas como si estuviera legalmente emancipado. Other exceptions include assets managed by a specially appointed curator, or property inherited by the ward from an estate where the guardian themselves was deemed unworthy to inherit. And, of course, any assets that replace these accepted properties are also excluded from the guardian's administration. Now, you might be thinking, if a guardian's power is so similar to a parent's, what's the difference? The key distinction lies in the level of oversight. A guardian's administration of the ward's estate is subject to much stricter rules and supervision. The goal is always to control, supervise, and ensure the ward's financial well-being. These rules create a set of obligations for the guardian, both before they even start their duties and throughout their tenure. Let's look at the obligations a guardian must fulfill before taking charge. First, they must create and submit a detailed inventory of all the ward's assets. This provides a clear baseline of the estate. Second, they have to provide a security deposit or bond, which acts as a guarantee against any potential mismanagement. Third, the court, after consulting a special supervisory body called the Guardianship Council, will set a maximum budget for the ward's living expenses and education. This amount is based on the ward's circumstances and, most importantly, the income generated by their assets. This budget isn't set in stone. It can be adjusted as circumstances change, but always with the council's input. In some cases, the court might approve something called compensation of fruits for maintenance. This basically means the court allows the guardian to use the income from the ward's assets directly for their upkeep, without having to account for every penny. But this is only approved after very careful consideration by both the court and the Guardianship Council. Once the guardian is officially in charge, their responsibilities continue. They can be grouped into several categories. Acts they can perform freely. Acts that require consulting another official called the protector, things they are required to do, and things they are absolutely forbidden from doing. Let's start with what the guardian can do freely. The general principle is that the guardian must manage the ward's assets to get the most benefit out of them. This includes all necessary acts of administration and conservation. For example, they should insure property against fire or accidents, clear up any issues with property titles, pay the ward's debts to avoid legal seizures, and pay all taxes on time. If the guardian can't manage the assets directly, they can appoint agents to do so. Other free acts include lending money with proper collateral, leasing property for an indefinite period, accepting simple gifts or legacies, and defending the ward in legal proceedings. Next, some actions require the guardian to consult the protector, who acts as a supervisor. The guardian co-ent initiates lawsuits on the ward's behalf without first hearing the protector's opinion, except for urgent matters or simple actions like collecting rent. The guardian also has to inform the protector whenever they receive payments owed to the ward. This keeps the protector in the loop and helps them oversee the guardian's activities effectively. Then there are actions the guardian is required to perform. Además de elaborar el inventario inicial, deberán presentar al tribunal estados financieros anuales, salvo que el tutor sea un abuelo. As we mentioned, they must notify the protector about any money received for the ward. Si el tutelado posee acciones o bonos al portador, el tutor, con intervención del protutor, debe convertirlos en valores nominativos a nombre del tutelado. What if the ward owns a business? The guardian must, with the court's permission, either sell or liquidate it. However, if the Guardianship Council believes it's clearly beneficial to keep the business running, and the court agrees the business can continue to operate, the guardian also has a duty to invest any available funds belonging to the ward promptly. Si no lo hacen sin una buena razón, pueden ser considerados responsables de la pérdida de interés. Now for the big one. What is a guardian absolutely forbidden from doing? The main goal is to preserve and grow the ward's estate. So, any act that would impoverish the ward without a corresponding benefit is off limits. En términos de contratos, generalmente se le prohíbe al tutor comprar la propiedad del tutelado, arrendarla o adquirir reclamos contra él. They couldn't even buy back the ward's property from a third party if they were the one who sold it. Furthermore, a guardian cannot accept gifts from their ward until the final accounts of the guardianship have been approved, unless they are a close relative, like a parent, spouse, or sibling. When it comes to inheritances, a guardian cannot accept one on behalf of the ward without the benefit of inventory, a legal protection that separates the ward's assets from the estate's debts. They also cannot refuse simple legacies that come with no strings attached. Finally, a guardian cannot benefit from any will made by their ward before the final accounts of the guardianship are approved, with the same exceptions for close family members. Lastly, there are certain major acts that require specific judicial authorization. The guardian cannot act alone in these situations. They need a court order to borrow money, mortgage or pledge assets, sell or encumber real estate or valuable personal property, or transfer credit. They can't acquire property for the ward except for basic household or administrative necessities. They can't enter into long-term leases, agree to make significant improvements to property, or reject inheritances. In legal matters, they can't submit disputes to arbitration, settle lawsuits, or agree to the division of property without the court's permission. To get this authorization, the guardian must prove to the court that the action is absolutely necessary or clearly beneficial for the ward. The court can request any information it needs, including a full inventory and current status of the ward's assets. Before granting authorization, the judge must hear the opinion of the guardianship council. If the judge's decision goes against the council's opinion, the case is sent to a higher court for a final ruling. Each authorization is specific to a single case and can't be used as a blanket approval for future actions. As you can see, the role of a guardian involves immense responsibility and is governed by a robust legal framework designed to protect the financial future of a child or adolescent. It's a system of checks and balances to ensure their best interests are always the top priority. Thank you for joining us on Lex Nova Junior. If you found this video helpful, please give it a thumbs up, subscribe to our channel, and hit the notification bell so you don't miss our next Legal Explicable. See you next time.